Ladies and gentlemen of the jury,
Have you reached a verdict?
Welcome to the John and Jordan on Justice podcast, your weekly deep dive into personal injury and wrongful death law.
all rise.
Touching on everything torts, legal tech, trying cases to verdict, and the outlandish stories that come with them. And now, here are your hosts, John Fischer and Jordan Redavid.
Welcome, everyone. Thank you for joining in to the John and Jordan on Justice podcast. I'm John Fischer here with my colleague and partner, Jordan Redavid. Jordan, introduce yourself to everyone.
Hey everybody, thank you for joining us. It's a pretty exciting day. John and I have been talking about getting this podcast off the ground for quite a while, and we've had some other things going on and finally had the ability, the time, and the resources and the team to get this done. So it's a big day for us, and we're excited for those of you who are able to join us.
Yeah, and I think, one of the benefits that we have is like we're, relatively younger lawyers in the game, I would say, although we may be getting quite a bit seasoned now in our experience and whatnot. But, we have a fresh perspective and have learned from some of the best that want to, give any knowledge that we can have to others as well.
Yeah, I think as this podcast continues to mature and evolve over time, we'll find a variety of different ways where hopefully we can give value to like-minded practitioners on the plaintiff side, maybe even some of those on the defense side, open their eyes a little bit. And of course, for the people out there who are just generally curious about plaintiff personal injury law or how these cases work, this is not legal advice and we're not starting an attorney-client relationship, but this should be informative and entertaining and hopefully educational. So, I was talking to John before we went on the air, and I felt like it's not going to be the norm where every week we just come out of a 2-week trial and we get a good winning verdict for our client. But we happen to be in that position now, and it coincides with this inaugural episode. So, John, maybe you can tell everybody a little bit about the Marsha Gonzalez case. We just tried it down in Miami-Dade County. Maybe give them a little background to catch them up to speed.
Sure. Yeah, we just, like Jordan mentioned, we just had a trial down in Miami in front of Judge Butch Go. It ended up being a 7-day trial, which was a new experience for us because the trials we had, I've never had a trial go over 5 days. Basically, it was a crash back in 2018. Our client was a passenger in an Uber. She was T-boned pre-suit. Before the case got to us, the at-fault driver ran a red light, tendered the policy limits, but there was an uninsured motorist claim. Uber had uninsured motorist coverage at that time. So the claim went, it was against Progressive. And we were not the original lawyers in the case. There was a case that another lawyer who had used to work for us had a firm. They had filed suit, and then when he kind of came back to join, he wanted to bring this case with us, and that was kind of one of the reasons he came back as well, giving us the opportunity to work this case up. So great client.
I was going to say, as you say that, it reminds me of the reality that I don't want to take for granted, which is obviously most people can conceptualize a person gets in an accident. A person hires a lawyer, that lawyer pursues the at-fault driver for the accident, and it seems pretty linear. But in a case like this involving Uber, I think a lot of people don't appreciate that there's potentially two, or at least at the time, two buckets of insurance from which to make our client whole. Obviously, you have the at-fault driver, which you talked about, and they're insured did the right thing early. But then you also have insurance, and stands for uninsured or underinsured motorist coverage. And John, maybe you can just explain to the audience just a little bit for those that don't know what the role of that insurance is and how common it is in our experiences.
Sure. Basically in Florida, and I'm sure it's like in other states as well, is that when an individual that hits you, they have a certain monetary amount of insurance. Although it's not required in Florida because we are a no-fault state, we have personal injury protection. So not everyone carries bodily injury coverage. So as responsible drivers, what people should have is they should have their own uninsured motorists, and that is insurance that's kind of steps in when the person that hits you either doesn't have enough insurance to cover you or doesn't have any insurance at all. And, so in this scenario, the person that hit Miss Gonzalez had $100,000 of coverage. The uninsured motorist was $1 million policy above the 100,000, which afforded our client the opportunity, because she had, pretty significant orthopedic injuries and ultimately a traumatic brain injury, to go forward and go after that additional amount of insurance. So they kind of stand in the shoes. So it's a really it's not unique in the sense that, most claims involving, well, it's unique in the sense to motor vehicle crashes, but, it's not unique in the sense that, many states have it. And it's really something that everyone should have. And in Florida, you get it unless you reject it. So if you get bodily injury coverage, if you don't reject you have it. So it's a way that people can have additional protection when they're in these crashes to get compensated. And that ultimately was the claim. We filed suit against Progressive Insurance Company for those benefits for Ms. Gonzalez. And ultimately we found ourselves in a courtroom when we could finally get there.
Yeah. So just for conceptually for the audience, the at-fault driver was not really a part of this lawsuit in any material way and had really nothing to do with trial insofar as it was just Progressive standing in the shoes of that driver. But liability was not at issue. It wasn't disputed. In fact, this is an interesting case because so many of the issues were not really disputed, right? Who's at fault? Was our client actually injured? Those things are often disputed, even in automobile cases. But when they're not, I think some people have a habit or a tendency to view that as, oh, this is great. I mean, the defense is just ticking things off of our list and removing hurdles that we have to jump. And I think on the one hand, that's true. But on the other hand, it also puts the defendant, in this case, an insurer, in a pretty sympathetic position. But, when they show up, they're not fighting tooth and nail over everything. They look eminently reasonable. And they're telling the jury from day one, or the court is through a preemptive charge, look, nobody disputes that the other driver's at fault. Nobody disputes that the plaintiff's hurt. And so it puts us, I think, back in the crosshairs to say, well, then what's the dispute here? And I think right from opening statement, and I definitely don't want to skip over jury selection, but I think, right from opening statement, that became clear to the jury. They didn't even dispute the orthopedic injuries, the broken ribs, the broken shoulder, a portion of a broken neck. It was only a dispute about whether she had a brain injury, and if so, the extent of it. And that really, I think, was a benefit for the defense. And ultimately, in my opinion, I think what helped keep the verdict down, because it made Progressive look eminently reasonable, that they weren't nitpicking through everything. They were just focusing on the big ticket item. But before we get there, let's actually jump back. So you said this case was tried in Miami-Dade County. We were in front of Judge Beatrice Butchko. And, I think, I don't know what your experience is. My experience is the following. In order to have a successful trial, and that's a subjective measure, of course, you need to be prepared yourself, and you need to have your case in chief go off without a hitch. But I think you also need competent defense counsel. I think, it's like any competitive environment, whether sports or in the courtroom. If your competitor is of a high quality, a high caliber, and he or she or they are putting on an A performance, I think it elevates your game. I think that definitely happened here. We can explore that. And also you need a judge, not just a judge who's going to sit and judge impartially, which she obviously did, but she listened feverishly, was taking notes incessantly, and she was right on the ball, whether or not we won the objection or not, but she was doing everything that we would want of a judge. So John, maybe you can take us back, since you're the one that did voir dire. We showed up to court in 2022 to try this case. And you were voir diring on a 2018 accident. And so there's a delay there. So maybe you can catch us up from, the time we took over the case, what delays there were from COVID and everything else to even get this case into the courtroom where you could start picking a jury.
Yeah. What's interesting about that is that generally the longer cases tend to go, the worse they get. This case was kind of the opposite. It was like the longer this case went on, actually, the better it got. We were originally set for trial. We got brought in early or late 2019. We were set for trial in 2020. They wanted a continuance because, she started seeing a neurologist. They wanted to have a DTI MRI, all of these, the things that were suggestive of a brain injury. So they asked, said, look, we need additional time to have that happen. So they moved for continuance, and then obviously it got continued, and we all know what happened in March of 2020, which was everything shut down. So
but it's also interesting too, because the whole court shut down for everybody statewide. My presumption is probably nationwide for some period of time. And I don't know about you, but as a trial lawyer, if I'm not getting into court with a high enough frequency, I start getting anxious, because this is what I want to do. This is how I feel like we can best add value to our clients. And our clients are sitting there doing everything they need to do. Like in this case, Marcia was getting all of her treatment, uncovering new medical issues and making sure she was getting properly evaluated. But on our side of things, there's only so much you can do until you try the case. And so I was really grateful to the court system and the judge and the other side to make this case one of the first ones tried on the other side of the pandemic.
Yeah, I mean, it was one of those cases that we were special set for January, and then we had that random uptick. I forget the strain of COVID. Jordan, you might remember what it was.
I can't keep up with them anymore. All I know is it seemed like every time the door was about to open, it got slammed shut again,
right.
And with good reason. But anecdotally, by the time we tried this case, masks were not a factor. Some of the cases we tried earlier, the first case we tried after the pandemic, right? Witnesses had masks. We had to have them unless we were in a certain position, taking proper precautions for people and their safety. But this actually felt a little bit more like a pre-pandemic case when push came to shove, right? I mean, we didn't have any of the masks or shields. And I think, putting the health component aside, because we have to defer to the experts on that. We're not that. We just go by what they say. I think from a human communication side, it's really nice when we can speak to people without that interference from a persuasion standpoint.
Yeah, I agree. And it did feel, I mean, we finally got it was in the, for those of you who haven't been to the Miami courthouse, the first few levels of courtrooms, they're the large courtrooms. Once you get up into the upper levels, they're the really small courtrooms. So this was the first one that we had been able to try in the larger courtroom, which was very nice to have that larger opportunity rather than feeling like you're in a sardine can trying to try a case, standing over top of witnesses, like, defendants and plaintiffs are right next to each other, so that was something that I enjoyed. Learned a little bit about the history about, the Miami-Dade courthouse. But
yeah, actually, you saying that reminds me, it's funny, you decompress from trial, you forget so much until you're reminded. But you're right. I remember when Judge Butchko started voir dire, she was actually educating the panel on the history of the courthouse, how it was coming up, I think, on a century of being in use and what it used to be and all that. And the irony was every day we stopped at 12 sharp, punctual for a lunch break. And every day we walked down those courthouse steps, and to our left or right, whichever way we exited, there's all these cranes building what I'm assuming will be a brand new, beautiful courthouse. But I don't know about you, but I take away from the case a lot of things, one of which on a personal level is a level of gratitude to be able to have tried one of the last cases in that historic courthouse in one of the more historic courtrooms. That was a nice experience for me.
Yeah, it was. So when we were able to finally I think we got the call for this trial the Thursday before. We were originally set in January. We were supposed to go special set for a few months. And then the Thursday before, and then the Friday, ultimately, they pushed it because of the COVID spike, COVID concerns. Our judge was very receptive to trying the case, but I think some of the other judges, the admin judges, just said, look, can we push this? And then with any difficult of a case, your special set, I mean, there's cases you get pushed back, and then there's other cases in the next month. And
it's a lot of hurry up and wait.
Yeah, we had an opportunity to get in, and that's what we did. And Jordan was in Atlanta, so he flew down, and we kind of took a very, I think we had between defense and plaintiff, 13 experts. Not to say that that's too many in one context, but a lot to,
it was a lot of work. We had built this case up, prepared this case to try it only a month or two earlier, 2 months, and couldn't do it. So we kind of put it to the side a little bit, focus on other things. And then, I think it was a Thursday morning, early morning. You sent me an email that says, we're going Monday. I had to drop everything, pack my bag, pack my suits, get on the next flight out, kiss my kids and wife goodbye, and hit the road, which, that's the life of a trial lawyer. And I'm grateful for the family I have to support me like that. But, I'm sitting here and I'm thinking all of this talk about getting to trial. And I realized in doing so, I'm overlooking something that was a little bit unique for us. We've tried many cases before this, but we had never actually committed the resources to do a comprehensive quantitative data analytics focus group. And we have done focus groups in the past. We've commissioned them ourselves on other cases, but this was the first time we went out and we spent a substantial sum to have someone who knows what they're doing, who is a lawyer, him and his wife, and they went out and they canvassed, what was it, John? Like more than 400 people across the country.
Yeah.
And this was a really interesting experience because obviously to focus group a case, it's common sense to say the participants need a presentation of both sides. And the way that this particular company did it, most of the presentation was through written, but we had our client give a statement, and we really gave the defense the benefit of the doubt on all the quote unquote favorable evidence for them to really get the accurate data. And what I found was the data was incredibly specific, targeting on things that you and I perhaps in prep were overlooking or not elevating to the level that they should have been. I don't know. What was your opinion on some of that data that we got back before we got to try the case?
Yeah, it was very insightful because we took, so one of the issues that was not before the jury was whether or not our client was wearing a seatbelt, right? There was allegations that she may not have been wearing a seatbelt in the rear passenger. Now she's not required to, but we had gotten a summary judgment ruling based upon an untimeliness of evidence submission by the defense, and we got summary judgment on our favor. But we ran the focus group as if she wasn't wearing a seatbelt, right? So we kind of added some negative factors. Was that at that time we didn't know if it was going to come in or not come in, so we ran it without it, or with it being our client was not wearing a seatbelt, and then with some other negative facts. And so what we were able to see, what was interesting is that sometimes the amount of money that you asked for that was higher got less favorable results. And then, so they ran them like in different cycles, but then you get to see like people's open-ended comments about your case, right? Like,
yeah, I agree. That was to me the most compelling. That's the jurors that you always want to know what they're saying. You never know if the actual jurors are telling you the truth. When you do a focus group like this and you get an Excel document with page after page of the jurors' own typed messages, I agree. That was really insightful.
Yeah. And what they thought about the client, so it's like, these are the things we need to focus on. These are the things that we need to stress. This is this is what's not important. Some things that you may think, I can't think of specifically something that I thought would be important. Or they were like, what's interesting is they were like, look, maybe you should focus more on the orthopedic injuries, but at trial, it kind of seemed like because the orthopedic injuries are not in dispute, why are we spending so much time talking about them? So, so it's a very insightful thing because to get an idea of like, this is what I thought was bad, this is what I think was good. And
when you try enough cases, I think anybody who's tried cases, and for those people listening who aspire to try more cases, I think we all feel the same way, which is we want to be authentic to ourselves and we want to rely and defer on our experience, our past experience in courtrooms to say, this is the type of argument that'll work, or this is the type of delivery or metaphor, whatever. And all of that's great. I think there's tremendous value in experience. But the data doesn't really lie in this context. And so like I can share maybe on the other side of the coin, yeah, it's insightful and all that, but on the other side, it's how surprised I was. So, early in my career, I was an assistant public defender in Miami, and I got to try a lot of cases there. And I'm super grateful for that opportunity and the people in that office who trained me. And what I found is when you try case after case after case, there's a habit or a tendency to notice what you think the other side perceives is a relevant factor in selecting a jury. And so oftentimes in the criminal context, but still I see it nearly as often in the civil, I think a lot of people on the other side and our side included, they tend to stereotype or group about race, gender, ethnicity, educational background, national origin. And I say stereotype in a literal sense, meaning just saying, well, generally, if we're not sure, we'll default to X or Y based on this particular demographic or point of data. And I've always been uncomfortable with that because it's a bizarre way to treat the human being. So in this context, the data, if it did anything, was it showed us that really didn't matter. Remember, I mean, we had said, look, we're trying in this Miami-Dade County. We think the general populace of the veneer might be of this kind of demographic. And the data showed that didn't really matter. Other things did, I mean, to some extent, the educational level, but there were like really specific things. What type of TV shows people watched? I mean, that was really, I thought, like an interesting data point. It was like, if you watch this type of show, you're generally not favorable for our side. If you watch this type of show, you're generally favorable for us or whatever, vice versa. So that was what I found pretty interesting, that it kind of reaffirmed what my suspicion had long been, which is that some of these stereotypical ways of approaching voir dire, or at least the selection process, don't carry weight, and you need to be focusing on other things. And as the person who sat in the courtroom watching you conduct voir dire, maybe we can, flash forward to that point in time, I found that it made, because I've seen you do voir dire what feels like a million times, even though that's not literal. And I thought it allowed you to be really focused, really targeted, and extract some really meaningful information. So maybe you can talk to the about voir dire.
I think, to kind of what you said, really early in my career, I did have those stereotypical implications of like who I want. And, I learned, and kind of what changed for me, a couple things. What changed for me is like, look, like Keith Midnick's approach to jury selection, I think is very important. And his approach to entire trials as well is very important. And we've seen good success having done that. Nick Rowley and his approach of like, when everyone comes into the jury room, rather than looking at each person being like, oh, they're going to be bad for me, they're going to be bad based upon those stereotype things that you mentioned. It's like, you believe that everyone in this room, given the right opportunity, can give you justice, can give you, confidence in the right to recover for the client. And when you have that mindset, like, everything changes, right? Like, yes, I'm in there, and yes, I am looking for some cause challenges, right? I want to find the bad jurors and get rid of them. But you also want to try to build a tribe of people together, or sincerity with the juror, or jurors that you have a connection with. You've seen it. We've tried a case, and we'll never forget this, with a guy I felt I connected with. You were said, no way we can put this guy on the jury. We put him on the jury, and he's back there fighting for us. So it's, to me, it's like, we're like like the beginning of the trial, jury selection and opening statement is the most important part of the trial. To me, that's how I'm always going to
You
say.
ask a trial lawyer, their ego probably says closing argument, but I agree. Objectively, looking back over the career, I think voir dire and opening. Absolutely.
Opening, yeah, because and it starts with jury selection. Now, in this instance, we had 50 jurors, or maybe, like, actually, I think we had more than that. We had people waiting outside because
Right.
tobacco case that was supposed to be tried. So they had 100 jurors that were going to come in, and obviously we didn't need that many. So Jordan hired a company, Jury X, I think is the name of the
Yeah,
company.
shout out to Jury X and Mary Sheedy specifically. She's the analyst who came down and sat with us day for day, hour for hour, and helped. But yeah, they were great. By the way, that's another thing we had never done before.
Right. And we had, and it, and the reason why we were able to do this is because, we didn't have, like, this was a damages only trial, right? So we had won on all the big issues. So we knew, well, I don't want to say we knew, but we were confident that we were going to win. And it's just a matter of how much, right? So we can kind of invest those resources, in this particular case, to try to maximize that. So we had her in there, and they have their own algorithm, the way they work, and they came recommended. And then she was with us, kind of had an opportunity to do that. And so, I had 75 minutes. It's a shorter amount of time than I would like, um, to talk to 50 people.
Let me say, it's great to have a jury consultant. It's a luxury, obviously. It's frankly a privilege to have someone as qualified as her, with a company as competent as them, to give you the data. And when you end up picking a jury with their input and you have a higher degree of confidence, that's a snowball process, and that's great. So, working with a jury consultant like Mary and a company like Jury X, who's super competent at what they do, it obviously gives you a higher degree of confidence when you ultimately pick and impanel a jury than you might otherwise have. And there's a snowball effect to that. As the advocate, I think, you're starting with more confidence than you might otherwise have. But on a very practical level, for the trial lawyers out there, or the people who aspire to be one, there's like a functional benefit, which is your ability to pay attention. John's up there asking questions. So we've all been there. If you're doing voir dire, you want to be in the moment. You want to listen, but you also want to plan for what you're going to say next. And you can't really take notes. You're relying on your team members. We tried this case with Keela, who's a monster. She's a great trial lawyer, and she's super attentive, and she takes copious notes, and I do the same. But by having a live feed of the transcript through our court reporter, which Mary was then, taking down, and her team was taking down, it allows you to have that confidence where, hey, I don't need to scribble down every last word uttered, because when push comes to shove on a preempt or a cause challenge, Mary's going to have the timestamp. And it allowed me to listen and get, whether it was handing you up a note, or when push, later when we were deciding who to select, it felt like I was allowed to be, for the first time in a long time, more involved in your voir dire than I otherwise would, usually am, as a scribe or something,
Yeah. And honestly, finding out information on potential jurors that we otherwise would not know, right? Like,
Right.
we wouldn't have that, or know, this person is from, does this, or this is their background, or sometimes, political affiliations. Like, you don't ask these questions of jurors when you're there, because especially in a damages only with 50 people, I'm just talking about money, how they feel about, economic damage, non-economic pain and suffering. Does it go away? And you, to have that backdrop, and it was pretty correct, right? Like,
Yeah.
they had someone that was like, put this person on the jury. Jordan had a note that said basically anybody but this person.
Keela did too. Like we were just like, stay away, not too much of a risk.
Right. And then
Let's just cut to the chase. Who did that person end up being?
he ended up being
Person.
the 4-person and, was fighting for us.
Yeah, far more favorable than we could have anticipated.
Right.
I think
Started out,
X's data points were this person could go either way, but it's a risk. And Keel and I kind of interpreted that risk as let's err on the side of caution. When we got to the point where we didn't have the luxury of having certain parameters or not, and it was really like, is it this person or who's coming next? Jury X said, look, have the confidence, select this person. We did. This person ends up getting on the jury. She becomes a 4-person. And we know now in hindsight, I mean, she's back there fighting to make sure we get the most possible. So it's an imperfect art. It is far from a science, but I've been talking to people since this trial. I know you have. And now what I tell people is I used to feel like it doesn't get better than experience. And the only way you get experience is by doing, right? You got to be out there trying cases to be a trial lawyer. And I still hold experience in high regard. But now I realize it's that marriage between your experience in the past, the data that you can collect before and during. And if you can marry those two things together, you're putting your client and yourself in the driver's seat on this thing. And I think the result of the trial showed that.
yeah.
And I have to talk about this because it doesn't happen all the time. We've all been there. You've seen panels that are not talkative or too talkative. We've all seen the lawyers out there who treat it like a stand-up comedy hour. But here's a situation where, you were taking it very serious. You were asking penetrating questions, some of them uncomfortable. And one of the prospective jurors, I remember she got kind of offended. You're asking me to talk about money and I don't know this and I don't know that. And I don't know if I could ever do this and do that. And she basically got to the point where she was telling you in front of the whole room, I don't think you're being fair, Mr. Fisher, with how you're asking me this question and what
Right.
you're asking me to tell you. And then
Did she say something about she felt like I was attacking her or something like that? Or
she
some
called you
words
out.
to that effect.
Yeah. And what happened? 2 people over to her right, to our left, a younger prospective juror stood up and in the middle of voir dire interrupted that person and said, no, Mr. Fisher's not attacking you. He's not asking you something improper. You're not properly understanding, and basically said he's entitled to this information, treat this process fairly. And it was it's a pretty big moment. And they let her go on the jury,
Yeah. Yeah. I think she wanted to say that she just wants to know if you can give money for pain and suffering. That was the idea. I went from medical bills to pain and suffering. And then, it was very, it was nice.
It's good to hear you say pain and suffering now, because if you check our notes to you while you were up there, non-economic and economic, non-economic, non-economic. I was teasing you when you were up there. I'm like, these people don't know necessarily what non-economic means, speaking in lay terms. But
I know. But
look, we went through that selection process with Mary right by our side. I think she was an integral team member in that part. It's not like we defer to her entirely. It's still a collaboration, but I think the client ultimately benefited. And let's just be real. By the time the jury got impaneled, I think me, you, and Keela, we left that courtroom. We had a high degree of confidence that we had won the day.
Yeah. I mean, and that's the thing about trials. Really, if you feel like you're either even or winning the day, that's what I want to have each and every day of trial is that, I come in, this is the time that I'm either going to, when I feel like opening statements, and the defense did a really good job in opening statement about our case. That was it didn't feel like we won, but
Let's give a shout out real quick, because I don't want to live in an echo chamber. Lead counsel on the other side, his name is Jaime Baca. He's with the firm Wicker Smith, and he was the lead counsel for Progressive. And he's a lot of things. All of them are things people should aspire to be as a trial lawyer. He's a straight shooter. He's an incredible advocate. He's articulate. He's attentive. And now that I have tried this case against him, I can say without hesitation, he is, if not the only reason, the primary reason, I think, why the jury came back with a number as low as they did. And it's hard to ever say 2.5 million is a low number, but in light of what we asked for, which was over 30, it's a very low number. And I think, hats off to him. We can all be competitors. We're going to see each other in a different case. I think we both mutually feel there's a deep level of respect and admiration for his craft.
Yeah. Yeah. I mean, and going into opening statement is one of what I feel like is the most important thing about trial advocacy, especially being the plaintiff in a personal injury realm, is that I don't ever want to lose credibility with the jury, ever. Like that is to me the most important thing, is that they think I'm credible. They, who is the most credible voice in the room. And so that is why, a lot of it's, hats off to Keith Mitnick and whatnot, but, we take the bad facts, we try to either make them our facts, put them in context, or kind of just eat them. And so that way there's nothing really that they're going to get up and say that we haven't talked about. And even though I had done that, an opening statement, the way that he gets up and did his presentation and opening, it was great. I mean, it was good. It made me, like, okay.
Have you ever, before Jaime's opening, had you ever felt sympathetic for an insurance company? I never had.
No.
And the way that he explained everything to the jury in opening, there was a moment there right from opening, I was like, holy shit, I think this jury might be looking sympathetically at Progressive, like they're the victim here. I really felt that. And that's not an easy thing to do, and he's been doing it a long time. But, look, I started saying this earlier in the podcast. When you see your competitor out there, if you're playing basketball, just draining them or whatever, like it makes you want to rise to the occasion. And I think we did that, and the result reflects that. But, opening statement, you mentioned Keith Mitnick. I know you study him a lot, and it shows you've been able to incorporate a lot of those things, make them your own. I think this is a good thing to talk about briefly, because we're all out there, all trial lawyers. We're listening to other podcasts. We're reading other people's books. We're going to seminars, CLEs, whatever. And what do you hear universally? You got to be you. You have to be authentic and your genuine article. And I agree with that. But that doesn't mean you can't borrow from a colleague who's come up with something that works, and then work on it, find a little tweak, and then make it authentic for you. And I think, as your partner, I just want to celebrate you and give you a little shout out. I've seen you come a long way, and where you're at now, and especially in an opening statement. I mean, I have seen in recent trials where the defense lawyer follows you in opening. It says, I know Mr. Fischer just talked about this, but I want to talk about it again anyway. And boy, have you just taken the wind out of their sails, because now the jury's like, I don't care. I already heard it. So,
right. Why are you telling me this again? And I think that's what makes it very effective, is that you take what you already just told them. And I mean, you've seen me when they have Facebook photos and I'm showing them an opening statement. Here's the photo. They're going to show you this. They're going to see this. You're going to see this. Oh, here she is smiling with her child at it, in another trial. And I was like, but what does this smile not tell you? Is that was the day that her father came home to hospice. Right. And they never even showed the Facebook photos in trial.
Yep.
After
they intended to, I assure you that.
But after that, they never even showed them once again, and so there's ways that, if you don't know about these big trial lawyers, like, as younger lawyers ourselves, that's how I've tried to grow and develop, is like learn from the best, see what they do. The CVN is the Courtroom Viewer Network. You can watch these guys in trial. You can see what they do. I mean, I looked at, Nick Raleigh's trial against Home Depot that he had, Jamie Beltran, where, he's describing the brain injury and the way he did that opening statement. Like, I liked that presentation. So I borrowed pieces of that to kind of, and obviously make it our own. So this
verdict is proof that this kind of thing works. You can cobble together and borrow from colleagues, but as long as you take the time and commit the energy to make them your own, they can work. And the client is the ultimate one who benefits here. Let me ask you a question.
Okay.
Because this has been like something, I don't know. We could try another 100 cases. I don't know if we'll ever get another case where the impaneled jurors asked more questions of witnesses in this case. Okay. So for context, for people out there who weren't there, what did we have, John? Like about 20 witnesses, it felt like, maybe a little less.
I think like with live witnesses, maybe it was like over 10. We had some by video. I think we had 4 witnesses by video, I think 3 on our side, 1 on their side, but the rest were by in live presentation. And like,
we had 8 jurors at the time. We had 2 alternates, right? And here we go. We're starting this case now. For background, I could probably count on, it wouldn't even take all 5 fingers on one hand to count the amount of trials before this one where jurors had asked questions of witnesses during trial. It happens. It's not, for me, it's not common, but it happens. I'm not surprised if it does. But I have never had a case where every single witness, except for one, which we can talk about, but every single witness from start to almost finish got asked more than one question by more than one juror. I think we're up to court exhibit 30, single page, single spaced handwritten notes by, only witness 4,
Yeah. When our client took the stand, for instance, one juror had 15 questions written out. 4 pages of paper. And so,
by the way, great questions, so let's stop. Let's not just talk in the abstract. These are in the court file, they're public record. Some questions, you're doing your best live to figure out, is this good for us? Is this bad for us? What does this mean for us? Some of them, it's hard to tell, but some of the questions after our client testified were, do you feel beautiful anymore? They asked her, she was a female, our client, I noticed you don't have kids. Do you want to have kids? If so, if not, why not? And that elicited a very raw, real emotional moment, as did that question about beauty. Our client talked about some very private matters, about thoughts that have come through her mind. And the jurors were just right there with us. At first, I'll confess, I felt a degree of skepticism. They were like, for example, we put on her father and her brother and her best friend, and these were our before and after witnesses. And at first I was like, oh, the jury's skeptical of them. But it turns out, with the benefit of hindsight, Monday morning quarterback in this thing, they weren't skeptical. If in hindsight, what they were doing, at least in my perception, is they just wanted to validate, we were asking for a lot of money. I think we asked for 31 million. We told them in opening. And I think they just wanted to make sure that they had all the information they needed and they weren't getting cheated out of, oh, well, the lawyer didn't get this in. And so kudos to them. A lot of jurors, some of them, we've all been there, they doze off, not this panel, right? They were edge of their seat, questions asked. Sometimes the judge would read their questions, the witness would answer, and then the jury would have follow-ups. And so it got to the point, I think, correct me if I'm wrong on this, John, at some point you strategically decided on one of our own witnesses not to do a redirect, and you made a comment. I'm not going to do a redirect because
I don't think I did any more redirects. I was like, I'm sure the jury has questions, and they did, like for every witness. With the exception
let's just say this, that's the jury getting the information they need. So let's not stand in their way. Right.
And that it was interesting, like very, very insightful. And in fact, we played, it was, our neuroradiologist was by video. We wanted them live, couldn't get them there. And they, one of the things they said before we played it was, we're not going to get to ask this person questions. Right. So they wanted to ask questions. They wanted to speak to the experts. And so, that was a very unique experience.
Now, they asked questions of every witness, as I recall, every live witness except for one. And what I found really interesting here was, so we had rested and the defense was putting on their case. And I don't know if it was at lunch or one of our, late midnight sessions with me, you and Keela prepping for the next day. I think we jokingly had said, wouldn't it be crazy if during the defense's case, the jurors stopped asking questions? And if so, would that be favorable for us? We thought maybe so. Meaning their mind had been made up. But of course, the first witness goes on, defense expert, and they ask her a ton of questions. So that didn't come to pass. But the last witness in the case was a big witness for the defense. It was their, rebuttal, essentially their competing radiologist. And in a brain injury case with brain imaging, that's a big witness for them. Did not ask the man a single question.
Right.
And Jaime stood up, as you did earlier in the case, and said, oh, I won't do redirect because I'm sure the jury has questions. And then everybody, collectively looks over at the jury with waiting eyes, and it's dead silent.
And no questions. No questions. So, and we thought that was pretty favorable for us. That they had basically made their minds up, that they recognized that she was injured, kind of the brain injury stuff, and I think the jury verdict really reflected that.
I agree. Can you, we're talking about. I had talked about. I think we were. Prepping, night after night, you break from trial at 5, you go out, you grab a shower, a bite to eat and some coffee, you're right back at it every night. Maybe you and Keeler eating dinner, drinking espresso, and then going right back to the war room in our hotel. But maybe you can talk to the jury a little bit. Not even just this trial, all of our trials, what it takes to get the case across the finish line, because, we don't shut off at 5.
Yeah. I think trial is mentally and physically exhausting, in the sense that, when I'm in trial, everyone's like, oh, like go to bed early, do those kind of things. Like, I'm just not that guy. Right. For some of them, they're outside my control, but, I'm up late, We took 2 expert depots during trial, one of which was our rebuttal expert by video for preservation, and one of which was the orthopedist for the defense. But you go home, you get out of trial, you get back to the rooms, you go out, get something to eat, you come back, and it's like 7:30. You got to go for the next day, and so the benefit of trying to maintain that energy, so that by the time closing happens, you get through your case, you still have that energy, and so it's difficult when you're doing that like late night work, having to prepare for the next day, but it's beneficial because we're able to split it up, right? So like I didn't, this is one of the things that, and we'll talk about in a moment, like I struggled with is like, giving away work to other people. I mean, that's just my nature.
You live with the case longer. Keel and I came in on the tail end, and I think most people try cases in teams. I think what I see most commonly is 2-member teams, and historically for us, that's what we did. But this is a case with a lot of work, a lot of interesting dynamics at play, and this was an opportunity. We had tried cases with Keel before, but this was an opportunity to bring her in as well. From an allocation of labor standpoint, I think having 3 people, it's kind of what I want to do from here on out, unless it's a short trial with maybe 5 or less witnesses. Because, in order to do your job effectively, and I don't know how you feel about this, but you have to have the capacity, the bandwidth has to be there to do it right. And like, even on this trial, I remember we went into it thinking that you were going to be responsible for 2 witnesses. And the way that the presentation of evidence came out with scheduling, those 2 witnesses ended up getting backed up onto the same day, which we didn't really think would happen. And so that night before, you and I strategically, credit to you for kind of, I think, earmarking and saying, look, I got to prepare this expert direct. It is an immense amount of work. Can you step in and do this cross tomorrow? And I said, yes. But I think, from a preparation standpoint, if I had said no, or we were just stuck in our ways, that would have put you way behind the 8 ball. And I think ultimately hurt the client in our presentation of evidence.
And I think being able to do that, kind of like, look, trial's fluid. You got to be flexible. I'm flexible. I try to be. And I had everything got backed up. I was supposed to get the neuropsychologist done on Wednesday. They didn't. I think they had to come back Thursday, but then they were calling their neurologist out of turn, which was kind of unique because, and Jordan can explain this, like, tell them like they called him out of turn, but we had listed him on our witness list. So we had asked the judge, said, fine, but we want to do the examination first, right? Since they were calling him, in our case, chief.
Yeah, it's not unheard of, right? You and I have been in cases where the defense, says, one of our experts due to scheduling, they're going to be in surgery. They're only available on date X. We need to call them. And it's during our case. And obviously we never want to have our presentation of evidence interrupted and like that. This was different in that, we did the research and there wasn't much directly on point precluding it. It was this particular witness. She was on our witness list. We have a habit of listing them in an abundance of caution. And we collectively, the 3 of us decided, look, let's propose, fine, you can call her out of turn, but we're going to examine her first. That way the jury doesn't pick up on or elevate this person's importance. What's the difference? And there's rules of evidence on it that permit that and give the judge broad discretion on examination of witnesses. So the defense kind of agreed to our proposal. Fine, as long as we can call her out of turn, then you guys go first. So this particular witness, she was an interesting witness. She's not the type that has 700 different cases with the same insurance company in the last 3 years, and she's a seasoned vet in terms of expert witness work. But she is very accomplished, outside of expert witness work, and doesn't do a high volume of expert witness work, at least not with this defendant. So strategically, we kind of had to figure out, okay, we're calling this person out of turn. We don't want to do the defendant's job for them by conducting their direct, but what can we do that will kind of eviscerate her credibility before the defense can come in and even get her off the ground? And what we decided to do was, I read through the depo that John took of her in discovery. And it's a super long depo because it was a super complicated area. And what I found was about what amounted to like 8 pages collectively of good answers that she gave that were clean, right? Yes or no, with very minimal explanation, that were favorable for us. And although there were other answers that we would have loved to get in front of the jury, because it would have been great, I made the decision, look, I'm examining her. I am only going to ask this person. There will never be a question I ask that I don't have a page and line ready to impeach her if she says something different. John got on board with it. Keela got on board with it. And so we tried it. And I have to say, I don't know how you feel, but as the one doing the examination, I felt like it went exceedingly better than I could have anticipated, because all experts, well, I don't want to say all, but most experts just have a natural tendency to not want to agree with what the other side is asking, merely because it's the other side asking. And even when it got to the point, what did I impeach her 18 times in a row before you would
Something
think
like
the witness would say, all right, I know what's coming. If this guy's asking me the question, he's got the answer. And she never did, and kept fighting me. There was a time she's like, oh, I didn't say that and all this. And we spoke to one of the jurors after they agreed to speak with us. And I think their feedback was they kind of just threw her testimony out.
Yeah, I mean, the reality is, Jordan tries to undersell her expert work. She's worked for Progressive 63 times in the last 5 years on 63 cases. She tried to say she didn't know that. And then she said, well, I don't even know who the defendant is in this case. So I was like, wait, you're getting checks from Progressive. You don't even know that? Well, I don't know that. Then it turned into, oh, I was attacked by me in Depot, and there were like live bullets flying. And that must, when she got impeached, like the last time, she's like, oh, that must be when you broke me down, and so like, I don't think, when she got up in there and, very simple questions and then tried to play the victim card, that didn't go over well. Right. And Jordan, I mean, at one point was like, you stop doing the whole, you remember giving a deposition in this case. You were there. I was there. Court reporter was there. You were under oath. You swore to tell the truth, just like you did in front of this jury. Let's go back to that page 76, line 3. He stopped doing that. It's like, doctor, page 83, line 4. You were asked. And then she was like, oh, no, but you got to read the paragraph before that. But, and I was like, no, doctor, this is what you were asked. And this was your answer. So it turned her into, there was a discrepancy in one of the medical records of whether our client had pre-existing anxiety or panic disorder that was in a blood order, right? It was in a blood order, not in the actual diagnosis from the doctor. And they were kind of jumping on that because there was an anxiety mental aspect to this case. She actually, because of the examination, finally conceded, well, you know what? I will accept that doctor made an error, that's an error, right? And the Progressive was using that in their case. So, when you have that, take a good deposition. And I used to not take depositions of CME doctors, right? I'd say they're bound by their report. That's all I need. But I have found you can go, right. You can go and ask questions. Was she hurt? Yes or no. What are you going to say? No? Of course you're going to say yes. And then you move for summary judgment on causation now, or in her instance, she said, by definition, her loss of consciousness. Yes, she had a traumatic brain injury. And that was important is because in opening statement, they said, look, saying someone had a concussion is not the same as saying someone had a traumatic brain injury. Well, this doctor in her depot said that a concussion is a traumatic brain injury. It's a type of it. So like, it was a very effective presentation. And then there was another scheduling error with another defense expert. We said, no problem. We subpoenaed him. We'll call him. And, they said, look, we're not doing that again. So
that's when I knew it must have gone over well.
Yeah. So
I don't want to make it seem like the trial was a breeze by any stretch and all favorable. I think we're highlighting some of the highlights, which is, what we do, but let's touch on one more thing that sticks out to me as a positive and something that was unique, doesn't really happen in all of our cases. And then I want to switch gears and talk about, in my estimation, some of the reasons why the jury didn't return a verdict as high as perhaps, we wanted. Because I'll confess, there was a degree of disappointment when the number was read for me. But the last part that doesn't happen often, one of the defense experts, we got to conduct our Dalbert challenge, essentially, had a hearing outside the presence of the jury towards the end of trial. We had already been in trial for a week. We had filed a motion before trial. Scheduling couldn't allow it to get heard. Then we were in trial. So we finally found a lull, and the judge was kind enough to accommodate. And she came live. And John, maybe you can talk about it since you were the one that did the examination argument. But, spoiler alert, the defense actually withdrew her before the judge could make a definitive ruling.
Yeah, I think that, live in trial, the judge kind of had some gap in testimony for the defense. So just kind of afforded us an opportunity to conduct the Dalbert challenge during trial. She witness came in, actually testified, and had to admit that she deviated from standardized testing. And when it was a neuropsychological examination. And when they do that deviation, that they basically it's not peer reviewed, it's not tested. There's an unknown error rate. It's non-standardized and can't say it's generally accepted. And based upon those are the Dalbert factors. So The judge initially, I think, was inclined to deny the challenge based upon saying she's qualified. And then obviously with further argument, that it seemed like she was inclined to grant the challenge. And so I think the defense, I mean, look, they have run other cases. They had what they needed, I thought, from one of the doctors. So they kind of withdrew the expert.
Yeah, it just doesn't happen all the time. And again, I think it probably would have hurt them, to be totally honest, if she had been permitted to testify. It's one of those weird situations where you feel like it's a win-win for your client. The judge is either going to keep the expert out and we get to move to closing sooner. We already feel good about how the case was going, or the judge is going to let this witness in. And I just knew in my heart, if that happened, yeah, we'd have an appellate issue. Great. But John was going to, crush her on the stand, so to speak. And I just thought, so it was a win-win, but again, kudos to Jaime Baca, right? He realized how the hearing was going and probably made an assessment, is my guess. I didn't ask him, that if this is how it was going with no jury, in front of a jury, it was going to go probably a lot worse. And so he made the strategic decision to
Yeah. I mean, look, it's like at every trial, to come back and be able to decompress and go through everything, some things worked out favorably, some things didn't. We actually have a few cases set for trial coming up here in a couple of weeks. So Jordan, we talked a little bit about, why you didn't think we got more, right? We, as lawyers, we always think we do a better job. And when you convince yourself, especially when I asked for a jury for 31 million, it's like, I have conviction. That's what this case is worth.
Right.
What do you think, in your assessment of some of the reasons why, we didn't get that full amount or an 8-figure verdict or something of that nature?
I think there's a multitude of factors. We'll never know all of them, but for starters, 31 million wasn't an arbitrary number. That's a number that the focus group and data analytics said gave us the best likelihood for the highest recovery for our client. So that was a strategic decision, but we backed it up we broke it down to per damage. Then we gave a time period, daily, then hourly, and how much money is it worth per hour. And I know people do this kind of thing, but here's what I found. We had an ample amount of time in closing to talk about the case generally. I felt like I didn't have enough time as the one delivering closing to drill deep enough to give the evidentiary support for some of those hourly numbers. Every juror, as I was talking, I had up the spreadsheet, I had up our calculations. They're feverishly writing. I took breaks so they could write. And I think in the moment that gave me a false sense of confidence that, okay, they're with me here. They're not really looking for me to go deeper. I've gone deep enough and they're satisfied. But the reality was, I think in hindsight, I wish I had more time, or that I had allocated more time to really explaining how we came up with that bottom number for each itemized category of damages, to explain why it was justified. Now, when we went back, they started deliberating. One of the first things they asked for was a whiteboard, markers, and a calculator, which I think generally is a positive thing. I think they're doing multiplication and addition, not division and subtraction. But I think in hindsight, I didn't get enough time with the audience to justify the number. And I think that showed with the number that we got. A huge win for our client, multiples of the prior offer, multiples of the policy limits. I mean, objectively speaking, trying this case was a massive win for the client, and that's got to be priorities 1, 2, and 3. But for us as the advocates who spend so much time, investing ourselves in the case, and as you said, I like your word, conviction, believing that 31 million was the number. I remember in closing, I told the jury, this is not the time to negotiate. This is not, we set it high, they set it low, and you pick a number in between. This is the bare minimum of what the evidence supports. And they came in woefully short of that. So it's a good learning opportunity for me. I'm still not even done digesting that to figure out how in closing, I think I like the model, the formula we gave, but I don't like, I want to work on my ability to explain it a little clearer for jurors. What about you?
Yeah. I think the reality is when you're asking for that kind of money and the plaintiff looks normal, right? With a brain injury case, you can't see a brain injury. You can see a person that's in a wheelchair. You can see the fact they're paralyzed, or, but when a person has a significant brain injury, you can't see it, right? So I think, if we look at some of the negative facts, I mean, she looks normal at trial. She's at a job where she was a statistician beforehand, at a functioning at a very high level, was at a more difficult job with more responsibilities, doing more work. So she's back working harder, looks normal, and then is traveling, right? And sometimes internationally. I mean, those kind of things are like, this is not the kind of person whose life is to the point that they need that much recovery. And I think that's, some of those.
The testimony came out that she had actually gone to Aspen Colorado
Right.
and tried skiing for the first time. So
Right. So, and a lot of the, and for good reason, the defense focused on that, and then I would too, and and so I think that like kept the number to a point where it was like they're just it's hard to say that what am I going to be financing her life of travel, right?
yeah, we have always tried cases where our client's sitting there with us. And this case was no exception. Ironically, we debated and we're thinking not to have her there every day, but due to scheduling, she was. In the future, do you think the next, traumatic brain injury case we try, are you going to have the client there?
No, absolutely not. I don't think in any case I'm going to have my client present in trial, because the reality is the jury can look at them and they say, if they're uncomfortable sitting in a jury box and our client doesn't look uncomfortable, why are they entitled to money? So I think the only time I'm going to have the client there is jury selection, opening statement, and when they testify. That's it. I mean, we had talked about that. That was the plan, but then for scheduling reasons, it didn't work, and we thought it would be disrespectful to the jury since she had been there to then stop coming. But I think that it would have been perceived that she was just having a bad day and didn't come, and I think it would have been even better for us. So, look, you always have to learn from trial, learn from the good, the bad, and the otherwise, and it's kind of like put that one to bed, decompress, pick it up, and we're on to the next one. We got.
Yeah. Speaking of that, we've got another one coming up at the beginning of May. But we'll probably do another episode here. You're talking about learning. I feel the same way. I want to learn from my past, and I want to focus on the future. Maybe you can foreshadow. I mean, it's not like we have a set itinerary, but what do you hope to accomplish with this podcast in the future?
So, I mean, look, man, the reality is yourself, you and I are passionate about trial advocacy, right? Like, I think that the workup is extremely important, but I don't get excited about the workup. I get excited about trial, right? And no one wants to go to trial. And I think that trial is the great equalizer. So I really want to focus on, learning about, bringing guests in that talk about trial, that talk about getting there, the ways they work, handling client interaction, expectations, like all of those kind of things, like a multifaceted approach to the practice of law in a personal injury setting, but with a primary focus on trial. Because I think that, as the younger generation of lawyers come, we need to be the ones kind of taking the reins for trial. Like, as we're coming up, we're going to be trying more cases. Some of the older guys are going to probably stop trying as many cases. Maybe, I don't envision myself trying cases into my 60s. Like, that's insane. But I mean, I think that we can focus on, bringing that, helping fostering growth, development, recognition of fears, things that I'm fearful of about trial, about the practice of law, things that I've done and learned over the last 10 years of running my own practice, 9 years, but, even like early on from school, and just kind of watching that development, that growth, and to be where we are now, which is much better than we were before. But I don't feel like I'm, to where I want to be. Right. I always want to be doing better and learning. And I think this is kind of how we're going to grow together, kind of thing. So
I absolutely agree. And I'm excited about the future. And, it takes a lot of work and a lot of time to get to trial. And there's a lot of stages in that process and steps. And I think we'll touch on those too, even from, case management system and what technological tools we're leveraging to make our jobs more efficient and more effective. And it will cover all those things in the future. But look, it's Friday before a holiday, at least in my house. And I think I have an Easter egg hunt to go with my little kids this afternoon. So I'm going to cut out, but I appreciate the time and I hope everybody enjoyed it. And I look forward to the next one.
Yeah, likewise. Thanks everyone. Thanks for tuning in, and we'll see you guys next week.
Thanks for checking out the John and Jordan on Justice podcast. If you enjoyed today's content, consider leaving us a review and be sure to subscribe wherever you heard this podcast so you never miss an episode. For more information or to connect with John and Jordan, check out @OnJusticePod on Instagram and Twitter, or check out Discord for plaintiffattorneys.com to communicate with them and like-minded plaintiff attorneys in a private Discord server. Until next time, this is the John and Jordan on Justice podcast.